Hey everyone, the inclusion of data privacy clauses in employment agreements is a critical element in today's digital age, where employers handle vast amounts of personal data from their employees. These clauses are essential for several reasons. First, they ensure compliance with data protection laws such as Singapore's Personal Data Protection Act, which mandates responsible handling of personal data. Second, they provide clarity and transparency by informing employees how their personal data will be collected, used, and protected, thereby fostering trust between employer and employee. Lastly, they mitigate risks by establishing clear protocols for data management, reducing the likelihood of data breaches, and the accompanying legal and financial consequences. The PDPA is Singapore's key legislation governing personal data protection. It applies to all private sector organizations, including employers, and outlines specific obligations regarding the collection, use, and disclosure of personal data. Companies must obtain the consent from employees before collecting or using their personal data unless exemptions apply. They are also bound by the purpose limitation obligation, which requires that personal data be used only for purposes that a reasonable person would consider appropriate. Additionally, employers must inform employees for the reasons for collecting, using, or disclosing their personal data to meet the notification obligation under the PDPA. However, there are specific exceptions in the employment context, such as the ability to use personal data without consent if it is reasonable for managing or terminating the employment relationship. For example, during recruitment, employers typically collect personal data to evaluate candidates' suitability for the role. This collection is permissible under the PDPA, as the candidate is deemed to have given consent for evaluative purposes. Another example is monitoring employee activities on company-issued devices. While monitoring is allowed, employers must communicate the extent and purpose of such activities to comply with the PDPA. Similarly, when sharing employee data with third-party vendors such as payroll processors, companies must ensure these vendors adhere to PDPA standards through appropriate agreements. Additionally, if employee data is transferred across borders, i.e. overseas, employers must ensure that the recipient provides a comparable level of protection as required under the PDPA, often through contractual clauses or binding corporate rules. Embedding a data privacy clause in employment agreements is more than a legal requirement. It signifies a commitment to ethical practices and employee trust. Companies must stay vigilant, updating these clauses to reflect changes in legal standards and technological advancements. Comprehensive data protection policies, regular training, and transparent communication with employees further reinforce this commitment. Employees too should educate themselves on their rights under the PDPA and engage constructively with their employers on data privacy matters. Understanding the importance of data privacy clauses benefits both the employers and the employees. It not only ensures compliance with Singapore's legal framework, but also enhances workplace integrity and trust. By prioritizing data protection, organizations safeguard their employees' personal information and strengthen their reputations. Thanks for joining me in this video. Don't forget to like, share, and subscribe, and I'll see you in the next video.